So, good afternoon, everyone. My name is Karel Dale. I'm chairing the fourth panel of the day on the African perspectives on ISDS reform options. I can see from the participants that there are still some people joining, so I will probably wait another 2 minutes before we formally start. The good news is that I can see that all my panelists in the meantime have arrived. That's very good news. So I can see. Okay, I think we will start and people will join us as we get going. So I think I'll introduce the panelists one by one as they come and address you. The way we're going to proceed is, so we have 4 speakers, and we have agreed amongst the panelists that each one of them will address their topic for 15 minutes. So I'll give a short introduction to each one of them, and then they'll do their presentation, and then we will have more or less taken 1 hour of your time, and then we will address all the questions that we have received in the meantime. So let me start with Mr. Mohammed Kebe, who is the first speaker. And Mr. Kebe is the managing partner of one of the leading law firms in Senegal, so Génie et Kebe. So he's an excellent lawyer, but more importantly, I think for this session, he's also one of the region's leading arbitration practitioners. And I think it's fair to say with a particular focus on everything, including OHADA. So Mr. Kebe is going to set the stage for us, and he's going to give us an overview of the investment landscape of the future in relation to the African continent free trade area and also OHADA. So Mr. Kebe, if I can give the floor to you, please go ahead. Thank you. You still have to unmute, I think. I can see a red microphone, so if you can just unmute yourself. I think you're still muted, Mohammed. Do you hear me actually?
I hear you, yeah. So can I?
Okay. Thank you. Yes, we hear you. Thank you. The floor is yours.
Thank you, Karel. I thank you very much for the introduction, and I'm very, very pleased to be there with my co-panelists to discuss this very hot and interesting topic. Given that the time is very short, I will be just going to discuss some overview of the current situation of the ISDS in Africa. As you all may know, Africa is one of the continents where most of the BITs now have been signed or is leading in this field. A lot of African nations have signed a lot of BITs over the last decades. And the outcome is that a lot of disputes arose from this. And over the last, let's say, 10 years or less 20 years, we have seen very steady growth of investment disputes against African nations. And Africa has been steady target on disputes. And most of the African nations, sub-Saharan or in any other region, have more or less been facing situation where a dispute were at stake. So this has led to some extent to some questions over the last 10 years or over the last 20 years. The reason is that we have seen that most of these countries, when they were facing investment arbitration, they were being losers. I mean, some statistic anyhow demonstrate that African countries were not very lucky with investment arbitration. Of course, this is discussed and debated, but I mean, most of the African nations have raised the fact that they have concern against investment arbitration against ISDS. One of the reasons is that they mentioned that it's not transparent. They mentioned that the awards are very huge compared to their economic situation. They mentioned that also that sometimes it's challenging their sovereignties. And for these reasons, we have seen over the last years some trends going to question ISDS and also going to see what reforms can be adopted in order to mitigate these effects. These challenges are on both domestic level and on regional levels. On domestic levels, some countries have set up some domestic legislations aiming at challenging the ISDS or the way it is conducted. South Africa, Tanzania, Namibia, Egypt, and other countries like have recently set up some domestic laws aiming at mitigating ISDS or to some extent at withdrawing even to ISDS. Other solutions that have been proposed is on the regional level. We know that Africa is composed of what is called the building blocks, the regional economic communities, in Southern Africa, in West Africa, in Eastern Africa, in North Africa. And each of these regional economic communities have set up some responses to ISDS. The South African Development Community, for instance, through its finance investment protocol, has limited the use of ISDS, requiring that disputes be resolved in local courts and tribunals. The East African Community as well, they have a model investment treaty, which specifically include a provision stipulating no ISDS. And in West Africa, we have the ECOWAS Supplementary Investment Act, which does not provide for ISDS, but rather includes a provision that investors use local remedies to resolve disputes. So one of the issues with reform under regional bodies, however, is the lack of uniformity between policies pertaining to the same country, because some countries in Africa are part of several regional economic communities, and states that are party to several agreements are given sometimes the ability to somewhat manipulate the process by forum shopping. So this is where situation stands now, if I can say so. And what we are discussing here is what solution can be proposed to challenge this situation. I am discussing here two possibilities. The first is a regional level through what is called OHADA. OHADA, as you may know, or as some of you may know, is an intergovernmental organization in sub-Saharan Africa, including 17 countries. Many of them are Francophone. We have two other countries like Guinea-Bissau and Equatorial Guinea that are Francophone, but they have adopted the ECOWAS system. And why the model of OHADA is interesting for us and why we are proposing it as maybe not a standard model, but as a starting point. Because OHADA has set up two levels of systems dealing with dispute resolution. The first one is they have set up a series of acts called Uniform Act that applies to the 17 countries. And this Uniform Act deal with any industry regarding business law, and to some extent, investment laws. Why this model is interesting? Because in the 17 countries of OHADA, when you deal with any legal situation falling under the scope of the Uniform Act, there is no domestic law, but you have the OHADA Act that will apply. And these Uniform Act address corporate law, security law, debt recovery, accountancy, arbitration, and recently mediation. So the importance here is that whenever you navigate in this country doing business or working in the investment sector, you assure that you don't face any challenge dealing with change in legislation, because no single country in these 17 can by its own change the law related to OHADA. This is the first level of the system. The second is that in terms of dispute resolution and in terms of ISDS to some extent, they have set up a supranational court called the CCJA, which sits in Abidjan. And this court is somewhat the Supreme Court of the 17 countries in any matter regarding these acts I have mentioned earlier. Concretely, if, for instance, you have any litigation in these 17 countries that is dealt with the local courts, when it comes to the appeal on the last resort, you don't deal with the Supreme Court of the country's members, but you have to refer the matter to the CCJA, that is the last Supreme Court. Now, the interest with ISDS within the CCJA is that the CCJA has also an arbitral component, which is the Center of Arbitration under the auspices of the CCJA. It is a neutral and independent body, but it sanctions also the investments, disputes, and any disputes dealing with arbitration within the region. And in the last amendment of the Uniform Act of OHADA, there was a specific provision dealing with investment arbitration. And within OHADA regions also, there is a trend encouraging the countries to adapt in their investment laws provision, allowing them, when it comes to ISDS, to refer matters to the CCJA. This is why we think that it can be on a model that can be, to some extent, proposed as reform when dealing with ISDS. The other important reform that can be set up when dealing with when dealing with ISDS in the continent is, for our perspective, the opportunity that the IFCTA can provide in terms of dispute settlement. As we all know, the protocol as it is drafted now seems to refer to state-to-state dispute settlement. But if you look at the provision, Article 27, I think, refers also to a possibility of arbitration without clarifying how this would work when it comes to deal with this. Now, why we think that this may be a good opportunity to reshape the ISDS system? Because we think that in reality, IFCTA may be a good starting point for setting up a continental dispute settlement regime that would also include every litigation in terms of state-to-state dispute settlement, but also in terms of ISDS. The reason why I think so is that in other regions of the world, notably in the new UMSCA with Mexico, Canada, and the US, we see that there is a new trend going to reshape the ISDS in a way to withdraw not completely from ISDS, but in a way to mitigate all the constraints that have been raised against ISDS. And we think that the IFTA can, to a certain extent, duplicate some provision of this treaty. We think so because most of the challenges that have been raised over the last years against the ISDS, particularly when dealing with African countries, is that it was shaking their sovereignty. When we talk about expropriation, even when the basis is for health reason or for environmental reason or for even sovereign reason, African countries have been receiving claim before arbitration, and they have raised their concern about this. Or if you look at the new UMSCA, it is very clear that these constraints and these challenge and these concerns have been taken into account in the way that states may have some new legislation on environment, on health and civil situation without being challenged on this situation. The other reason why we think that the FCTA may be a good starting point for reshaping the ISDS in the continent is that most of the African countries have challenged the way ISDS is working now in terms of cost, in terms of transparency, and also they are arguing that all the cases are being dealt outside Africa. And we think that having a court or a dispute settlement system and mechanism and body in Africa with African panel, with the panels composite with African scholars or academics or practitioners, maybe can have a certain preponderance with what African countries are raising in terms of transparency and in terms also of situation that is not always in line with their interest. And we think that in doing so, there is a certain way to strike the right balance between states' interest and investors' interest. The reason is that for us, if the new system allows to have state-to-state dispute settlement or an ISDS settlement, when it comes to situation where states would not like to initiate any claim for political reason, because we know that African countries, they don't want to initiate claims between themselves. But when it comes to the situation where there is some constraint for having state-to-state dispute settlement, we can have a mechanism that allow investors to start their claim themselves and also to be sure that they are not relying on the volunteer of the states to do so. And this is why we think that by and large, if we look at the IFCTA, and given that the negotiation will be continuing on the dispute settlement mechanism, African countries can take this opportunity along with what OHADA gives us a model to see how they can reshape the dispute settlement mechanism. And by doing so, they can take into account all the concern they have raised against ISDS and see how they can mitigate it in this new system and see how also they can push all the African countries to give their green light on this and to cooperate on this. And maybe this will allow us to have something from Africa dealing with claims in Africa without being strictly avoiding to take into account investors' interest. Current time is very, very, very short. I don't know if I have out of time, but this was the contribution I would like to make about the issue. Of course, I'm happy to respond to any questions if there are any. Thank you very much for your attention.
Thank you, Mr. Kebe. I'm sure we will have, at the end of the session, further time to develop some of the ideas that you have so eloquently presented to us. We will now continue with the second speaker of our panel, Mrs. Susan Kimani. Mrs. Kimani is legal counsel at the Permanent Court of Arbitration in The Hague. She's also a qualified advocate in Kenya. She is actually in the process of obtaining an LLM degree at Harvard University. So she's clearly a very intelligent person if you manage to study at probably the best or one of the best universities in the world. And she is also the former co-registrar at the Mauritius International Arbitration Center. So she presents the ideal combination, I think, of a scholar, a practicing advocate, and someone who has seen also the major institutions dealing with these kind of disputes in action on a daily basis. So Mrs. Kimani is going to address us on the possibility of introducing some sort of appellate mechanism, and she will also discuss the proposed MIC system, which is at the Multilateral Investment Court. So over to you, Susan. You're still on mute, so the floor is yours. Thank you very much.
Thank you, Carol, for your kind introduction, and thank you to the AFAA for organizing this conference. It is a privilege to be part of this panel and to engage with the esteemed panelists and you, the attendees, on some of the proposed reforms of the ISDS system. If you attended the previous session, you will have noted that Anna, the Secretary of Untitled, painted a broad picture of the reforms that are currently ongoing at Untitled. And I will only focus on two of the proposed reforms, as Carol has noted, that is the establishment of a standalone review or appellate mechanism, and the establishment of a standing multilateral investment court. And after that, I'll highlight some of the perceived advantages and disadvantages of this mechanism from the perspective of some states that are participating in the discussions. And finally, address how more African states can participate or further participate in the reform discussions. But before I start, I will note that the Permanent Court of Arbitration, with which I'm affiliated, has become very active in ISDS in the last decades. And since Untitled Working Group 3 started its work, the PCA has been commenting on the work of the working group as an observer. But the PCA itself does not take any view as to the desirability or lack thereof of these reforms. And the issues that I will highlight represent the options that are currently being considered by the working group. In fact, they remain quite controversial within the working group itself. They are still under debate. And again, as Anna noted earlier, the work plan of the working group foresees finishing the work by 2025. So finishing the discussions by 2025. So it is still too early to tell, for instance, which form the reforms will eventually take. But moving on to the appellate mechanism. The proposal by some delegations is to set up a separate appellate body that would mean the current ISDS regime would maintain most of its basic features and be complemented with a standing or at least a semi-permanent appellate body. And the appellate mechanism could also function as a second instance of a multilateral investment court, or MIC, if one was to be set up, but I'll come to that later. And the aim of the appellate mechanism is to increase the procedural and substantive correctness of decisions, to increase predictability of BIT interpretation, which is one of the issues that has been perceived as plaguing the system. With regard to the features of an appellate mechanism, I will highlight 5 features that are emerging from views at the moment in the working group. And the first one has to do with the scope and standard of review. So many delegations agree that appeal should be limited to error of law and manifest errors of fact. fact. Now, with regards to errors of law, this has been quite uncontroversial. The difficulty or the controversy has to do with errors, manifest errors of fact. What will constitute an error of fact? Is it determination of facts that were clearly erroneous in the first-tier tribunal's decision, or would it be manifest errors in the appreciation of fact? The working group seems to be leaning more towards the latter, that is manifest errors in the appreciation of facts, because many delegations view that perhaps these would ensure that appropriate deference is paid to the first-tier tribunal. But the intention is to limit the grounds of appeal so that the process is streamlined and the process is fast. Now, the second feature pertains to the treatment of the existing grounds for review. As we all know, we have grounds of annulment under the Exit Convention. And on the other hand, we have grounds for refusal of recognition and enforcement under the New York Convention. And some delegations view that there is no need to keep the annulment and set aside remedies in addition to the appellate mechanism, because this might de facto create a three-tier dispute resolution system that in the end runs counter to the objectives of finality and efficiency, which the reforms will be trying to achieve. So a pending question to think about is how would we eliminate, if at all, the current grounds for review? Would domestic courts be willing to defer their authority to an international body? Question to think about. A third feature pertains to the types of decisions that would be appealable. Many delegations agree that final decisions on merit and procedure would be subject to appeal. What is controversial is interim measures decisions, challenges, and jurisdictional decisions. Views are divergent on this, but there is a strong view that decisions on interim measures should not be subject of appeal at this level, because this would have a negative impact on the cost and duration of proceedings. These measures are normally also quite specific to a case and temporary in nature, and the tribunal that orders them could also be could reverse them. But what about decisions on jurisdictions? On jurisdiction here, again, the views are quite divergent, because on one hand, it might be preferable for an appellate tribunal to be presented with a full record of the case before rendering a decision. And on this reasoning, an appeal should be possible if only after a final decision on the merits. But on the other hand, allowing an appeal on a decision on jurisdiction at an early stage might save cost and time. So instead of having to proceed to merits and then having an appeal at that stage, it could be done earlier. So the views are divergent on which would be preferable here. But another question that plagues the working group at the moment is if a decision on jurisdiction is subject to appeal, would the first-tier tribunal stay or continue its proceedings pending the appeal? So another feature to think about. Fourth feature is what would be the effect of an appeal against an arbitration award? A majority of states view that an appeal should suspend the effect of the first-tier decision, so that that decision would not be enforceable. It would not be subject to a set-aside procedure. And many states also agree that the appellate tribunal would be able to affirm, it would be able to reverse, it would be able to modify the decisions of a first-tier tribunal. The controversy arises around remand authority, whether the appellate mechanism might have remand authority to be able to remand cases to the first-tier tribunal. Some delegations say that the appellate mechanism, the appellate panel should be able to remand cases in limited circumstances. For instance, where the tribunal, the appellate tribunal, is not able to complete the legal analysis based on the facts available before it. But then concerns would remain on how to reestablish the first-tier tribunal and the additional costs that would arise in such a case. The fifth and final feature the appellate mechanism pertains to enforcement of appeal decisions. Now, this would very much depend on the setup of the appellate mechanism. If states were to agree on an appellate mechanism based on an opt-in convention, then perhaps an enforcement method, an internal enforcement method could be included in that convention. But according to the views of some delegations, there might be a role, or there could be a role for domestic courts under the New York Convention. But this is only possible if the decisions of the appellate mechanism are considered as arbitral decisions, because the New York Convention refers to arbitral awards or decisions of permanent arbitral bodies. And what about the ICSID Convention? Article 53 of the ICSID Convention provides that ICSID awards will not be subject to appeal or any other remedy except those provided in the convention. And so given that appeals are not provided for under the convention, a possible avenue that some delegations are considering as something that could be explored would be an inter-se modification of the ICSID Convention among the states establishing the appellate mechanism. Moving on to the proposed multilateral investment court. And the idea here would be to establish a standing mechanism that is called the Multilateral Investment Court with full-time adjudicators and potentially 2 levels of adjudication. The court would have, so the first instance layer and an appeal mechanism or a review mechanism based on limited grounds by a different panel. And the system as well could be an add-on to the current ISDS regime or be established independently from any existing institution. And the main proponents of the MIC idea, that is the EU and its member states, have indicated in a submission that they will be open to accepting an open architecture whereby the appeal mechanism might also be open to non-MIC signatories. So quite interesting, but also an issue under consideration. The main rationale of having a multilateral investment court is that from the view of some delegations, that by having judges sit permanently and decide cases over time, then they could deliver more consistent decisions. The main issue for consideration regarding the MIC is there are many issues, but one of the ones that I picked out is from the submissions and the reports of the working group is the issue of appointment of adjudicators to the court. Questions remain as to whether adjudicators will be employed part-time or fully employed at the court and not having any other activities. Whether states and investors have a role to play in the appointment of these adjudicators. There is a strong view here that investors should have a role to play in the appointment of the adjudicators. Otherwise, there would be a serious concern about the legitimacy of the arbitration court system. If candidates are to be nominated, then who will nominate the adjudicators? Will it be the participating states? Will it be by an independent entity that is established within the permanent body? Or will it be by individuals, or will it be a combination of different parties? And if eventually an appointment of adjudicators is to be carried out, is it going to be carried out by states directly? Is it going to be carried out by a vote of the contracting states? Is it going to be carried out by an independent commission? So all these are considerations that are currently being undertaken. The working group itself has not actually decided on the feasibility of a MIC, but if it were to be established, a point of convergence by many delegations is that the selection of and the appointment process of adjudicators should ensure neutrality and eliminate politics, and that it should involve both states and investors. But one also has to consider how issues of diversity are going to be addressed, including how to include more African arbitrators, how to include more women arbitrators in the system, an issue that has been highlighted in many different speeches and panels today. In the interest of time, I will just look at two or so advantages and disadvantages that came out in the submissions made by government delegations and the reports of the working group. Some delegations view that, and these include African countries that have submitted comments, that a court system, be it an appellate mechanism or a MIC, would contribute to improving the consistency, the predictability and legal correctness of investment awards. And this would eventually or generally strengthen the legitimacy of the system, again, an issue that has been perceived as plaguing the system. But there's a lot of perceived advantages, but I will not go into all of them. A major drawback that has been pointed out by delegations is that permanent mechanisms would lead to the loss of flexibility and the loss of expert decision making, the loss of the benefits of party appointment of arbitrators, and this would raise concerns again about the arbitration system and the future of it. With the few minutes I have left, let me address the issue of how African states, more African states and practitioners can participate in this discussion, and especially African states, because as the Secretary of Arbitration noted in a panel earlier today, this process is meant to be state and government-led. I note that a number of African states are already taking part in the working group sessions. For instance, in the last session that was held in February of this year, 11 out of the 54 states attending the session were African states. And in addition to that, 6 African states participated as observer states. And that brings us to a total of 17 African states in the last session. But that means that there are about 37 other African states that could still join this debate in the future. And so one of the ways is to actively participate in these working group sessions, either as members of Arbitration through the existing representation system, or as observers who routinely contribute to the working group debates and whose remarks are also, they also form part of the official record of the working group sessions. And another way would be by submitting comments and position papers and proposals to the Arbitration Secretariat on the ISDS reforms. Several African countries have consistently submitted comments on ISDS reform process, and this is very impressive, but there's still room for more African states to contribute and for their voices to be heard. And notably, this comments normally are included in the notes that are prepared by Arbitration and also in the reports that are prepared by the working group. Providing feedback and direction through intergovernmental organizations as well, such as the African Union Office of Legal Counsel, is also a way of participating. But finally, participating in regional African meetings, such as a meeting that was held in 2019 in Conakry that was meant to familiarize more African states on the working group's current areas of work and to also take up the views of more African states on ISDS reforms. And I'll leave it at that, Carol. Thank you.
Thank you very much, Ms. Kimani. We will now proceed to our third panelist. And it's my pleasure to introduce you to Mr. Mohammed Nem, if I pronounce the name correctly. Mr. Nem is a state counsel for arbitration and international disputes within the Egyptian State Lawsuits Authority. So that's the department of the Ministry of Justice in Egypt. Mr. Nem is apparently a very busy man, I think, because he's currently involved in 9 pending ISDS disputes on behalf of his government. So he's clearly a very experienced ISDS specialist who also sees things in action on the first line. He has also been appointed by the African Union as an expert consultant on the Pan-African Investment Code. And finally, I mean, there's lots more to say, but I have to make a selection. I was impressed reading that Mr. Name was selected by the Association of Young Arbitrators as one of Africa's 50 most promising arbitration practitioners. So it's my pleasure to give the floor to Mr. Name, who will address the issues of consistency, efficiency, and transparency within the ISDS regime. Thank you. The floor is yours.
Thank you so much, Karel. A very good morning, good afternoon, and good evening to everyone in different corners across the globe. At the outset, I would like to thank the organizers for giving me the opportunity to speak to you today amongst distinguished colleagues and practitioners from all over the world. I would especially extend my special thanks to the African Arbitration Association for organizing the conference in this, in the most efficient manner, given the current state in the whole world. So I will discuss in my intervention the African perspectives on consistency, efficiency, and transparency in investor-state dispute settlement system. During my intervention, I will address three main issues. The first of which is consistency and coherence of the ISDS regime. Then I will move on to the second point, which will be the issue of transparency and efficiency of the ISDS proceedings. And then I will finish by the Africa's role in ISDS reform. So the first topic to lead us off is the question about consistency and coherence of the investor-state dispute settlement regime. I believe that consistency engenders predictability, thereby contributing to the system's credibility and legitimacy. A legal system is consistent when it produces coherent solutions. So, by contrast, a dispute system where comparable cases produce contradictory results is unpredictable, which increases disputes and their associated costs. I believe there are 5 main factors that are catalysts and magnifiers of consistency. The first of which is the broad legal concepts. The legal issues addressed in investment arbitration generally involve legal concepts that are designed to be applied to a broad range of situations and are open to criticism and different interpretations. Further, the decentralized nature of dispute resolution under investment treaties contributes to its inconsistency. Treaties provide for arbitration in the context of different arbitral institutions. Besides the newness of the system, only the international investment law system emerged only in its current form in 1959, and significant case law in international investment law did not begin to take shape until the early 90s. Further, the factual commonality. Different cases with similar factual patterns are common. The fact that different arbitration tribunals address similar facts contributes to the risk of inconsistent arbitral decisions. Moreover, the public availability of awards. I believe that investment arbitration cases and decisions are often publicly available and regularly attract attention as they deal with state policies and matters of public interest. Although transparency may be seen generally as a factor that increases consistency because it allows arbitral tribunals and practitioners to have access to previous decisions, it also highlights contradictions among decisions by different tribunals. Scholars and the practitioners closely scrutinize decisions focusing on contradictions and thereby increase the perception of inconsistency. So the remaining question would be how to enhance and ensure consistency in the ISDS system. I can specify 5 main tools to enhance consistency. The first of which is the clear treaty drafting and use of exceptions and reservations. Differences in treaty language may result in different interpretations and outcomes. If a treaty is drafted clearly, it is less likely to lead to disputed treaty interpretations. The lessons learned from interpretation of early treaties have already been incorporated by many states into their new treaties, which are typically substantially more detailed than first-generation treaties. UNCTAD, for example, has expressly advised states to review their early generation treaties to revise any language that may be unclear. Furthermore, drafting substantive provisions to guide interpretations, potentially less precise as guidance for a tribunal, although equally determinative, is the text that links substantive obligations to an evolving area of the law. Moreover, the joint interpretation may be considered as a useful tool that states may resort to at their disposal in several regional investment agreements in order to enhance the ability to issue joint interpretation of their treaties. And finally, the availability of travaux préparatoires and adoption of stare decisis or jurisprudence constant approaches. Treaty drafts can serve as legislative history, which may be valuable assistance to interpreters. Where such texts are available, making travaux préparatoires to treaties available to arbitrators would be a welcome step, as they can be resorted to under the Vienna Convention to determine its meaning when general principles of interpretation leave it ambiguous or obscure. Let me then jump into the second point, which is transparency and efficiency of Isds regime. Actually, critics of investment arbitration have long condemned the lack of transparency at all stages of a dispute. Demands for increased public access to hearings, materials, and awards produced in arbitrations and disclosure of third-party funding have all become more widespread over recent years. However, recent changes in treaty practice and arbitration rules have increased transparency significantly, and today investment arbitration is more transparent than before. Recently, in August 2018, ICSID published its proposals for amendment of the ICSID rules, which aims at providing greater transparency by including provisions relating to access to documents, including arbitral awards, access to hearings, and participation of non-disputing parties in ICSID proceedings. Moreover, the ancestral transparency rules provide for hearings to be held in public and for a range of arbitral documents to be made public, including awards of tribunals. The Mauritius Convention also seeks to provide an efficient mechanism for states to apply the ancestral transparency rules. Current efforts by states to implement the convention are reflective of their perception of the text, as well as their attitude towards transparency. In this regard, the parties to PSG Resources Limited versus the Republic of Guinea agreed to apply the ancestral transparency rules with certain modifications intended to protect confidential information. The parties made all written submissions public, including the request for arbitrations, memorials, exhibits, witness statements, expert reports, hearing transcripts, and decisions of the tribunal. Additionally, the hearings were made accessible through a video link on the ICSID website. The tribunal had the discretion to admit or deny third parties from physically accessing the hearing. The parties also added a 30-minute delay to the video broadcast in order to protect confidential information. Let me then finish this intervention with the Africa's role in Isds reform. As the Isds regime is under scrutiny, the African continent is planting the seeds for its reform. This is evident in the development of new investment instruments at the national, bilateral, regional, and continental levels. These trends reflect African countries' desire to adapt the investment law game to their contexts, priorities, and realities. most importantly, they show a new vision of Africa that of a pioneer in setting innovative standards for the reform of the international investment law field. At the national level, some African states have modernized their domestic investment codes, such as the Egyptian Investment Law number 72 of 2017 and South African Protection of Investment Act of 2015. At the bilateral level, other African states started to rethink and reassess the substantive content of their intra-African BITs. African countries have recently started to move away from the classic standards of protection contained in most BITs towards more balanced investment agreements, such as the Morocco-Nigeria BIT. At the regional level, regional investment agreements have emerged within the African continent. By adopting their investment rules, Africa states play a prominent role in the development of international investment law, including, for example, the COMESA, ECOWAS, and SADC. And finally, at the continental level, a pan-African vision for investment regulation has been adopted in the form of regional instruments, such as the BAC and AFCFTA, as has been elaborated previously by my colleague Mohammed. Finally, I believe that there is a clear, bright future for Isds in Africa. However, it has been said that the future is not something we enter, the future is something we create. Thank you so much for your kind attention.
Thank you very much, Mr. Naim. This brings us to the last panelist of today, but certainly not the least, Professor Mohammed Abdel Wahab. Also for Professor Abdel Wahab, I had to make a selection of all his qualities and titles and relevant experience. So let me just mention just 4 of them because they're equally impressive. First of all, Professor Abdel Wahab is Professor International Arbitration at the University of Cairo. He's also the head of arbitration at the esteemed Egyptian law firm Sulfikar and Partners. He is one of the vice presidents of the ICC Court of Arbitration, and I wouldn't like to have him as my opponent, given the fact that in 2018, he was the winner of the International Advocacy Prize. So I prefer to have him as co-counsel and not so much on the other side. Having said this, Professor Abdel Wahab will discuss the new generation of African BITs and some of the reform options and proposals. So Professor, the floor is yours. Thank you very much.
Thank you very much, our esteemed moderator, Mr. Abdel. It's a pleasure to be part of this panel and of this great event by the African Arbitration Association. Without further ado, I will start by saying the benefit of speaking last is that you should either say nothing or concur with what my colleagues have already stated and elaborated on. I do not purport to do either, except that I fully agree with what my colleagues have addressed. What I intend to discuss with you today is to address the next generation of African BITs from a different perspective. Normally, when people consider that title, would expect to hear the traditional views about the change and using the Morocco-Nigeria BIT as a platform for changes to the BIT system, looking into the provisions. And this is all known to most of you, if not all. But what I intend to do first is to share some comments and reflections. These are motivated by a very important statement that I would start by making, which is those who do not reflect on the past, do not appreciate and analyze the present, have no future. And with that in mind, I will briefly take you to what I call is the African first generation BITs, African BITs 1.0, let me say. And this starts with since 1961, And if we were in a forum, a physical format, I would have challenged our colleagues and the audience to take a pick on which were the first African states to conclude BITs. And if people were to make a guess, normally they would think it would be either Egypt, South Africa, Nigeria, given the plethora of experience and wealth of involvement in dispute resolution that these countries have. However, they were not the first countries to have the BITs. Now, to give you an idea, Nigeria, for example, started having BITs in 1990. And the first one was with France, followed by the UK in 1990. South Africa started with 1994 with the UK. Of course, there is the termination of the South African and the adoption of the 2015 Promotion of Investment South African Code, which transposes and transplants much of the protections that are available traditionally in BITs. And Egypt, which could have then been a normal choice and a favorite for the first BIT, its first BIT was actually in 1966 with Kuwait, then in 1974 with France and Germany, then in 1975 with the UK. But the first 4 BITs involving African states came from Togo, 1961, and Morocco, 1961, Liberia, 1961. All of these 3 BITs in 1961 were with Germany. And then Tunisia adds the 4th BIT in 1961, but it was with Switzerland. So the African system of bilateral investment treaties started to take off in the 1960s and 1961 precisely. And this first generation of African BITs in 1960 in and of itself can be subdivided into a number of categories, passing through the 70s, the 80s, the 90s. But what I want to reflect now with you before going into the new generation of the 2.0 African BITs is to try and track what has happened in this. Now, of course, much of the literature addressing BITs would be divided into those who would make a correlation, not a causation, between bilateral treaties and the proliferation of foreign direct investment in African states. Others would say there isn't tangible data to support this type of correlation, let alone causation. But be that as it may, the African countries have engaged in numerous BITs. As we stand today, African states have concluded, that's not to take those who entered into force, but concluded, broadly speaking, no less than 1,020 BITs. This is out of 2,852 BITs known globally, which means that we are, with respect to the African continent, at the percentage of 36% of the world's BITs involve African states. And that includes both inter-African BITs and Africa foreign BITs. Now, over the years, and when we track this, we find a very interesting trajectory. Now, there has been a hype in African BITs. So in a period of 4 years, 1998 to 2001, so 1998, 1999, 2000 and 2001, we've had a hype of cases. And those who are interested in statistics would know that inter-African BITs in 1998, they were about 15. They dropped to 2 only in 1999. And then again, back to 15 in 2001. And then, interestingly, 35 in 2001. Now, the Africa foreign, which were much more, were 46 in 1999, 49 in 1998, and 42 in 2000, and again 42 in 2001. And if we were to track the trajectory, whether African states are increasingly entering into BITs or decreasing their BITs, you would notice that there is a fluctuation. It is not a monotonous type of equation where you see an increase or a decrease. You see a fluctuation. So it's not a one size fits all. Between 2010 and 2020, when we look at the new generation of BITs, we can track no less than 21 inter-African BITs and no less than 99 Africa foreign BITs. So Africa is pretty much not engaged in a demise of the BIT system as it stands. However, that said, what can we do or can track then in relation to the new generation of African BITs? Those who look into the first generation in the 1960s, 70s, 80s, and 90s would notice that they are pretty much primitive compared to the current structure of BITs. Few pages, disengaging on exceptions, not much to say about definitions of investments rather than, or investors rather than the traditional definitions. You have no carve-outs, no restrictions like portfolio investments, a threshold, looking whether the investment is real or fictional. All these matters are not addressed in the first generation, which actually builds on what Susan has mentioned in relation to inviting African states to reconsider the first generation, which some of which, by the way, have been renewed and are still in force. This brings into the mind the traditional example given by many, which is the Moroccan-Nigeria BIT, which is an inter-African BIT. And I know many of you are familiar with its provisions, but it's not a standalone BIT. We also have the Pan-African Investment Code, which can be a soft law instrument as a model of inclusive provisions. We also have BITs involving also Morocco and Nigeria and Ethiopia and Egypt and many others that raise the flag of a balanced equilibrium within the BIT context quite well. The new generation, there are features for what I call the new generation of BITs 2.0. And these features include a carefully articulated set of definitions of who qualifies as an investor and what constitutes an investment. And instead of the non-exhaustive list that does not include thresholds and offers an investor of even one share the protection on the BITs, the new generation considers with care who qualifies for protection under the BIT system. And this comes at a time when investment laws themselves are in reform. Between 2013 and 2020, we have no less than 12 to 15 investment laws on the continent that have been reformed. And with that reform, there have been again a level of sophistication as to the protection afforded to investors under local investment laws. So there have been a degree of, I wouldn't say competition, but a degree of eyeing investment laws and investment treaties to ensure that there is an alignment on the protection standards. And with that in mind, apart from investor and investments, most favored nation clauses have been reconsidered. Can you use them for dispute settlement or not? And the new generation says no of BITs, where you exclude that, and you would apply MFN clauses for substantive protection in the like circumstances and on bases that are articulated in BITs. They've also included innovative provisions on protection of environment, the state's right to regulate, labor and human rights protection, anti-corruption, anti-terrorism, and anti-money laundering. So issues of illegality that have been plaguing a lot of cases in a way. And I want to say here a word of caution. Much is being said and has been said about certainty and predictability, and that there is a disassociation in awards rendered to a degree that some may call inconsistency. We have to be reminded of a number of things in all fairness to those arbitrators that render the awards. arbitrators consider the cases on the facts presented to them, legal arguments presented to them, and counsel prosecuting the cases in a way. All these factors vary from one case to the other. And I very much doubt if we were to have a permanent structure, much will change because cases, as again, will be considered on the laws and the facts presented. Now, that does not mean that predictability is not desirable. It is absolutely desirable. A jurisprudence constante developed, absolutely yes, but that needs to be done with care as to comparing like for like in a way. Now, in addition to these new generation provisions, I call them, we have also provisions about corporate social responsibility, elements whether the investor has been subject to proper corporate governance, doctrines of clean hands that impact this, like good faith, finding its creeping way in relation to denial of benefits, rules about taxation measures and carve-outs from investment protection. And we've seen that the COVID saga brought about health and safety and security measures that can be a clock stopper to investment protections depending on the treaty itself and the wording. Dispute prevention, issues about transparency, as we've heard, and the state's right to counterclaim in investment arbitrations. All these are features that, as a matter of fact, are finding their way gradually and forcefully into the BIT system. Now, what does this tell us? Tell us in a number of things, and these are my important concluding remarks, which is basically that states are not losing faith in the BIT system and, broadly speaking, ISDS. I think the option of a permanent structure is tabled and is possible. The question is it mutually exclusive compared to traditional ISDS? That remains to be seen. Well, history, as I started, tells us that multi-options have existed, coexisted throughout history. And it is for states, investors, and players to consider what options work for them in specific elements. So that's the first remark. The second one is that the revamp in investment legislation brings on board a degree of alignment with international best practices in investment law, which will help create further clarity and strong edifice on investment principles. We also see a change in players, and that's my third comment. Traditionally, we've seen the UK, France, and many of the investors traditionally on the continent. Now we see the rise of Japan, Brazil, and China on the continent. And this is not just a subjective view. When we look at the 2020 BITs, because African states have concluded BITs even in 2020, and those who would look at the time span of the last 10 years would see a degree of fluctuation. 2010 had 15 BITs, 2018, 10 BITs, 2016, 18 BITs, and then 2020, we've had 5 BITs. And the 5 BITs were between Kenya and the United Kingdom, and that's the latest African BIT. Not, well, actually, it is called, and that is one of the comments I will make, Economic Partnership Agreement. And that was signed on the 8th of December 2020, just 3 days after the association agreement between the UK and Egypt on the 5th of December. We've also had the Côte d'Ivoire, or the Ivory Coast, and the UK Stepping Stone Economic Partnership Agreement in October, and the Japan Côte d'Ivoire BIT in January 2020, and the Japan Morocco BIT in January 2020. So there is a rise in new players on the continent mandated by their investment. Now, of course, again, the fourth comment I would make is a change in approach and terminology. Even though we talk about bilateral investment treaties, there is now a rise in calling them economic cooperation or partnership agreements or associations, like looking at the UK ones. And we can understand the UK keenness on that, given the Brexit and the desire to continue to benefit from the protections given formerly under the African, under the European sort of community. We also see, as my fifth comment, model BITs. African states are now engaged in developing template model BITs rather than a one-off BIT signed by whoever visiting in a protocol another state and signing an agreement that could be distinct from another agreement signed by the very same state a week later. And when we speak about inconsistency and lack of predictability, we should be mindful that BITs were drafted individually rather than having a model standard. Now, African states are becoming increasingly conscious of the fact of developing models. Egypt, for example, has had its model BIT of 2013 and now has a new model of 2019, which takes into account new innovative provisions, including, for example, disclosures regarding third-party funding. And the fifth or sixth comment I would make before I conclude my presentation is that in addition to the substantive protections, we see diversions on the continent in approaching dispute settlements. For example, the Brazil BITs with African states dispenses with ISDS and replaces it with SSDS, which is state-to-state dispute settlement, through what is called a joint committee of states, sponsoring or looking at the claims of investors and deciding whether the state would sponsor the claim and enter into an arbitration or a dispute with the other state. And that is a function of the new generation of potentially states going head-to-head with each other if the dispute cannot be resolved amicably through an arbitration mechanism. But it's not an investor-to-state arbitration. This is a function of Brazil African BITs. But in addition to that, we also see, for example, the Japan BITs, including the 2021s, where we see the ISDS system is maintained and the protections maintained, subject to a carefully measured approach and articulation of the protections afforded to investors and the rights afforded to states in addition to their obligations under the BIT system. So with that in mind, my conclusion is, I don't think that the BIT system will wither away. I would say that there is no demise, but there is a reconfiguration, a restructuring, a rebranding of the BITs. And with that, and the rise of investment laws on the continent, I am suggesting that we will have a multi-door option to states and investors to choose from, potentially permanent versus ad hoc tribunals, in addition to protections afforded under BITs, multilateral treaties, and investment laws. And let me share with you one experience. Within the MENA region, for example, we have the permanent structure of the Arab Investment Court under the Unified Arab Investment Treaty. This did not dispense and will not dispense with investment protections under BITs between MENA region states. It exists, coexists with this regime. And I think much can also be said in relation to many parts of the world. So I think as the system reconfigures itself, these systems of BITs and others will be rebranded, will be founded on a much informed view of investment protections that exist. And I think this needs to be tabled on the reform options in this respect. And with that, I conclude and I thank you all for your patience.
Thank you very much, Professor Abdel Wahab. This concludes the four presentations of the panelists, but of course is the beginning of our Q&A session. So I've been checking from time to time the questions as they were coming in from, I don't know, in the virtual world, if you can still refer to the floor, I think the virtual floor, if that exists. Anyway, so one of the questions that we received and that I would like to address because I think it involves more than one of the panelists is basically how are African countries reacting to these changes and to these proposals of reforms. That's the question that is coming in, but I would like to kind of add something to it, because during various presentations, for example, where we were talking about transparency and how much states would favor transparency, I was wondering, like, if that is the case, why are then so little states are actually signing up to the Mauritius Transparency Convention? So I've just checked the data this afternoon, and there are actually 7 African states that have signed the convention, but of those 7, only 3 of them have actually entered the convention into force. So it's an example, at least, I'm putting it to the panel, it's an example of where, on the face of it, states are interested in reforms, but are not really doing it in practice. Another example that I would like to give is that I heard Mrs. Kimani saying that, for example, in the discussions in the working group of the UNCITRAL, the UNCITRAL working group, of course, it's good, there's 11 states participating, but that means that over 75% of the African states are not participating. And I was wondering, is it a lack of interest? Is it the lack of resources? Is it the lack of awareness? Is it something else? Why the African governments are not using the opportunities that are out there? So, I don't know who wants to go first on this. Maybe Susan, if you can, from your perspective and your participation in the working group.
Thank you, Carol. Now, going to the question of the Mauritius Convention, you're right that the numbers are very low. In total, only 23 states have signed it so far, and it's entered into force in 7 countries. And the total number of cases that have been submitted to the UNCITRAL Transparency Registry are very, very low as well. And one would be tempted to draw a negative inference from these low numbers. But my suggestion is that the success of the current reform process and whatever implementation model is adopted will depend obviously on the commitment of states and their willingness to implement a particular reform. So I wouldn't draw a negative inference from the Mauritius Convention, because that is specific to that situation. It is less about the model, in my view, and more about the particular reform. And that is why the involvement of African states is very important, because they need, in the end, to be able to feel that they own whatever reforms result from the process. Now, yes, a large percentage of African states is not participating. As to why, I would only speculate. But what I would say is that the ones that are participating, they see this as an opportunity for developing countries to participate in reforming a system that was established without the participation of many of this, of the developing countries. And that is what you see in the majority of the comments that are submitted, is that this is a welcome initiative, and that is why the call is out there for more African countries to participate. And you will also see that the comments that are made by African countries are also very specific on a number of issues. For instance, there's an emphasis on the need to reduce arbitration costs. There's an emphasis on the need to recognize the needs of African states and the need to support African states in arbitration. So what will be important is to encourage more states to see this as a welcome initiative and to participate in it, so that they can own the reforms.
Thank you. Is there someone else who wants to add to this?
Yes.
Abdel, Wahab?
yes, absolutely. Let me say a number of things. I think African states' participation is indeed important as the system reform efforts are ongoing. But I'm more interested in qualitative rather than quantitative participation. One thing is to be present, idle, or unheard, and the other thing is to help shape the future. And I think African states have to consider carefully bringing forward the experts so that they can have strong voices in shaping the system. That's one thing. Secondly, we can see divergent trends in Africa. There isn't one uniform approach to ISDS. And I recall that Mali, for example, in September 2019, made a statement, and it's on the website of the Untitled, where it was against ISDS and in favor of SSDS, state to state, rather than ISDS, for a number of reasons that is outlined in Mali's statement. On the other hand, Morocco, in the very same year, March 2019, opted for a balanced approach, not dispensing with ISDS, but agreeing that it should stay with reform options about how the system should function. And so I think we have three broad categories of African states. Those who are against ISDS per se, and they are so far not the majority, and the majority that are, or a fair number of them, that are in favor of ISDS with reform options to varying degrees, and a number that are silent, not stating whether they are with or against. So I think it is fair to say that the continent remains rich in the divergent trends in relation to approaching ISDS. But what remains to be seen is that if a mark is to be left and ensuring an all-inclusive approach to reshaping the system and ensuring that we are downplaying whatever disadvantages or issues that people take on the system, that this is being shaped in a global all-inclusive approach involving African, Latin American, Asian, and other states. Because as we see now, ISDS is no longer a situation where developing countries are being sued. We see developed countries are being sued as well, internationally and regionally. If we look, for example, to Spain in relation to the solar cases. And so there are now, the system is not targeting a specific sector of states. And here I have to really praise and commend the efforts that are done by ICSID to assist states, especially first-time case states that are being sued. For example, ICSID, earlier than all these efforts and discussions, ever since 2015, has commissioned a report for respondent states how they can navigate their way in relation to ICSID arbitrations and what should be done. This is a very useful tool available to many states, and many states are not aware of. Also, the efforts undertaken by ICSID to showcase that the convention and the ICSID rules are well balanced, reconsidering the rules that are currently being under review as well. And we see now even developing countries and other countries joining ICSID recently. So the system is not against states in a way. And as a matter of fact, the reality is states win more than lose in investment arbitration. That is often a misconception, be it on jurisdiction or on quantum. When you look at the overall statistics, states win more than lose. So in fairness, I think we need to consider with tangible evidence where the system stands and how credible claims can be carefully considered, not simply denied access to justice in a way, be it for the state or the investor. Thank you.
Thank you, Professor. Just on that last point about states winning more than losing, I just wanted to mention that actually Susan and I have been working on some research in relation to a book that will be published actually by the chair of our previous panel, Lise Bosman. And just for your information, because I think it's an interesting statistic, we researched, or we investigated all the ICSID treaty cases. So I underline treaty cases, not ICSID contract cases. But so we analyzed and researched all the since 2010, so from 2010 to 31st of December 2020, we analyzed all the cases. Actually, there were 62 ICSID treaty cases in that period, 62. 41 of them are concluded. And of the 41 that were concluded, there was 21 that were settled or discontinued. So that's already half of those cases where at least, you know, the states do not incur liability, or at least if they incur some responsibility, it's based on a deal that they agree with. So half of the concluded cases are either discontinued or settled. And of the 20 cases that did end up in a final award, actually 9 of the 20, so that's 45%, were dismissed on jurisdiction. And there were another 4 that were dismissed on the merits. So of these 20 cases, 65% of the cases were actually dismissed. And only 7 of them, the state incurred some liability. So if you look at it, out of the 61, you know, since 2010 until 2020, out of these 62 proceedings, there are actually only 7 where the state was ultimately held liable. So those are the most recent statistics. I just thought it was interesting to share it with the group. I have, because we are running out of time, but I do have a question, I think, for Mr. Kebe, because he mentioned about OHADA and how they work with uniform acts. Is it contemplated that at some point OHADA could adopt a uniform act on foreign investment? Is that on the table? Is that being discussed or not?
As far as I know, this is not on the table of OHADA. OHADA was adopting gradually uniform acts. They started with corporate and securities, and recently on mediation. So I think that it depends on how a sector is growing in the continent and how it is growing within the member states. Maybe in the upcoming year, this is something they would consider. But as far as I know, currently, this is not, in their agenda.
Yep. Thank you. I think, do we have, it's one, yeah, I think we have time for, it seems I don't have time anymore for the next question. So I know, unfortunately it's late, and we'll have to conclude this last session of the day. I think, as a previous panel have said, we are obviously the panelists. We remain available to answer any question that come in online. So please don't be shy with any further questions, and we'll circulate them amongst ourselves and try to, come back to you. I would like to, through the WOVA app, you can post those questions, and also the answers will be posted there. Left me to say that I would like to thank my 4 panelists for their great presentation, and also the working together for putting this together, and thanking the conference organizers.
We want to thank you for your very capable moderation, Carol. And let me say one thing. Delighted, of course, I'm very grateful, and sorry to cut you off, but it's unintended.
Go ahead.
But I want to thank you very much and a request for you, because those who are listening to us, Carol published in 2012 an excellent book on challenge and disqualification of arbitrators. He doesn't know that I'm going to say that, by the way. So it is highly commendable. But my request to you is consider updating this leading text on that topic, because that is a very topical matter. And I would see.
It's all here.
Thank you. So that's the request. And I thought it's useful. Sorry to cut you off, but I think I wanted to thank you for that and make that request. Other than that, I'm very grateful and thankful to all my colleagues and all our audience.
Thank you very much. I'm blushing now. So it's I think it's time to switch off my camera and release all of you. I thank you very much, and I look forward to seeing all of you in the near future.
Thank you very much.
Thank you very much.
Thank you.
Thank you.
Thank you. Bye.
all.